Good evening. My name is Rocky Robbins. On behalf of the Board of Student Advisor and the Dean's Office, I'd like to welcome you all to the 77th annual final round of the Ames Moot Court competition. Tonight's case, Rathburn versus the United States, concerns the constitutionality of the federal sentencing guidelines and the Federal Sentencing Commission, which promulgated them. Petitioners challenged the guidelines on both separation of powers and excessive delegation grounds. The case is based in part on Mistretta versus the United States, which was argued by the record writer Alan Morrison, among others, on October 5th before the Supreme Court. A decision is expected out sometime in the spring. Presiding tonight as Chief Justice is the Honorable Louis F. Powell, Jr., retired Justice of the Supreme Court of the United States. And as Associate Justices, the Honorable Patricia M. Wald of the United States Court of Appeal for the District of Columbia Circuit, and the Honorable Juan Torruella of the United States Court of Appeal for the First Circuit. Representing Petitioner tonight, the Paul Freund team, will be Richard Rockman and Mayor Fader. And representing the Respondent, the Carl and Doug Llewellyn team, will be Mark Nielsen and Robert Miller. VSA would like to welcome everyone to a reception which will be held after the arguments in the Ropes Gray Room of Pound Hall. The reception is in honor of the teams, their families, and the judges. We're going to bring the judges in now. After they come in, they're going to sit down and we'll provide a brief 4 or 5 minute period where anyone who wants to take pictures may do so. After that, the bailiff will signal the beginning of the argument with as close as we can come to the traditional Supreme Court introduction. And after that time, there'll be no more photos allowed in the courtroom, with or without flash. And finally, a reminder for the spectators in this courtroom, there should be no applause or cheering until all 4 of the oralists have finished and the judges have retired from the bench to make their decision.
All rise.
You may proceed whenever you're ready. Oh, too early? It's a nuisance having this right in front of you.
Oyez, oyez, oyez. All rise. This court is now in session. All ye having business before this, the Supreme Court of the United States, draw near and ye shall be heard. God save the United States, and God save this honorable court.
Well, now you may proceed when you're ready. Where do you see if he was leading over? All right, Mr. Rochman.
Mr. Chief Justice, and may it please the court. My name is Richard Rochman. With my co-counsel, Mayor Fetter, I represent Petitioner Samuel Rathburn in this action. Petitioner challenges the constitutionality of the new federal sentencing guidelines. Mr. Fetter will argue that the commission that promulgated the guidelines was constituted in violation of the separation of powers. I will argue that the guidelines themselves are the product of an unconstitutional delegation of legislative power. The facts, briefly, are these. In 1984, Congress enacted the Sentencing Reform Act, granting extraordinary powers to an unelected commission to devise and implement a new sentencing policy for all federal crimes. Congress was dissatisfied with the lack of uniformity in sentencing by individual judges, who had wide discretion in imposing sentences. But instead of solving the problem itself, Congress asked this commission to make the key decisions and carry them into law. Congress was dissatisfied with current sentences, but the decision of where the new sentences ought to be set was left to the commission. Congress was troubled by arbitrary and unwarranted disparities in sentencing, but the decisions of which sentences are arbitrary, which distinctions unwarranted, were also left to the commission. And Congress wanted to eliminate the hodgepodge and chaotic nature of criminal sentencing, but it left the job of rationalizing the system to the commission. After spending 2 years working on these and other policy questions, the commission finally issued its guidelines, which became law automatically 6 months later. Petitioner Rathburn, who pled guilty to a single count of counterfeiting, filed a motion in federal district court challenging the constitutionality of these guidelines on both unlawful delegation and separation of power grounds. Judge Pritchard agreed that the guidelines were unconstitutional and thus declined to apply them in sentencing Rathburn. Application of the guidelines would have resulted in an automatic 18 to 24-month term imprisonment, but Judge Pritchard, because he believed that Rathburn would not benefit from and in fact be harmed by a term of imprisonment, sentenced him instead to 3 years probation. The Court of Appeals reversed, and this court granted cert on the delegation and separation of powers issues. Transferring the power to define punishments from Congress to an unelected commission is as unconstitutional as it is unprecedented. That transfer is a delegation of a non-delegable power and should be invalidated. But even if this court finds that that power may be delegated, this delegation is still invalid because it lacks sufficient standards to guide the commission's discretion. But underlying both of these arguments is the unprecedented nature of this delegation. This court has never before faced many of the issues in this delegation simply because Congress has never before attempted to make a delegation of this magnitude, involving decisions so central to the legislative function, decisions which rely not on technical factors, but on societal values.
Let me ask you a question. Why is what the Congress did in this case, as far as delegation went, different from the kind of indeterminate sentencing laws it's been passing since time immemorial, where it says the sentence for such and such a crime shall be from 6 months to 20 years, 30 years, and then the discretion is left with an individual judge?
Because instead of Congress wanted to reject, because Congress wanted to reject that policy and implement a new policy, the field changed. What judges
Why
did
did
in
the constitutionality of it change? There was the same delegation of choosing between those two extreme ends when an individual judge did it, that now that discretion has been taken from an individual judge and given to a sentencing commission. But as far as constitutionality goes, vis-a-vis an excess delegation, what's different about it?
And I think the constitutionality focuses on the two bodies. In the case of a judge making a sentence in an individual case, as the Hill v. United States case pointed out, a judge in that situation is exercising his or her judicial power. The commission, however, does not have a constitutionally granted or any inherent power whatsoever. It has only that power created by Congress and given to it. And because it is the commission that is then making policy for all federal crimes, it is the commission that is doing the legislature's work. A judge in an individual case is by no stretch doing a legislative function. He's doing, as the Hill case said, a judicial function. And the distinction of having the commission do it is the problem in this case. The decisions of defining punishment are society's greatest, harshest sanction on an individual, is society speaking as a whole.
Isn't it defining punishment within certain parameters that are established by Congress?
You mean the commission was, Your Honor?
Yes.
Certainly, Your Honor. And however, I don't think that guidance was sufficient to confine it, because it is exactly the statutory maximums and minimums that Congress found so wholly inadequate in a sentencing policy that it acted to make a new sentencing policy. The commission is now making new statutory maximums and minimums in effect, because the guidelines will apply in over 90% of all cases. So in effect, it is the commission who is making new sentences. It is
The only constitutional way that Congress can handle this, either to minutely define for each crime the specific punishment or to give the delegation to individual judges. Would it be unconstitutional if they gave it totally to the executive, to a commission composed of executive members? Would it be unconstitutional if they gave it to the Judicial Conference, which is composed of all of the chief judges in the United States? In other words, does Congress have no flexibility under the separation of powers or the excessive delegation theories to do anything but leave it with individual judges for time immemorial?
On the delegation issue, there would be nothing gained by making an executive commission or changing this judicial commission to a judicial conference. But yes, there is something Congress could have done if it was satisfied with current sentencing policy. I think Congress could have said to the commission, find out what current sentences are, pick those as the new uniform sentences, and that will be our sentences. In other words, Congress would just have delegated to the commission the fact-finding of what the sentences are and already had satisfied its policy obligation. But because Congress here wanted a completely new policy, it doesn't absolve it of its constitutional duty to articulate what that policy should be, simply because it would be time-consuming. That's not the measure. The measure is whether the power may be delegated, or secondly, whether the power, if it can be delegated, has been delegated with sufficient standards.
May I ask this question? Under the old law, the sentence could have been 0 to 15 years. The Counterfeiting Act provided that.
Mm-hmm.
Under the guidelines that you're debating here this evening, what could the defendant have been sentenced to?
18 to 24 months, Your Honor, in prison.
Could he have been sentenced to probation?
No, because the probation minimum would stop at, I think, around 6 months, and probation would not be available for that.
Under some circumstances, under the new act, probation is available, isn't it?
Yes, it is. Probation is still available, even when there is an alternate sentence. But in this case, because his sentence is 18 to 24 months, he was not eligible for probation.
Under the new act, may mitigating factors be considered?
Certainly, Your Honor, to the extent an individual judge may consider mitigating factors, to the extent they weren't considered by the commission. But as Judge Pritchard pointed out in the district court opinion, there were no special factors that could enable him to take Petitioner out of the guidelines.
In this case, you're 21 years old and poor education, living with an uncle who could have over-influenced him. None of those relevant?
None of those factors are relevant, although it's interesting, Your Honor, that you brought up the case of education, because that is an example of how indecisive and uncertain Congress was in making this delegation. In one part of the statute, 994C, Congress asks that the commission take into account education to the extent that it is relevant. Then in the very next provision, 994D, Congress says the commission should recognize the general inappropriateness of considering education.
The fact that he'd had no prior conviction of a felony would be relevant, wouldn't it?
It was certainly relevant, and it was taken into account when if the judge on remand were to sentence with the guidelines, the criminal history puts him in criminal history 1, and that would be the 18 to 24 months. That is what he gets with his lack of criminal history, his age, his education, and his offense.
Why are the standards in this case any more vague than the one in the Yakus case, which was, as I believe, generally fair and equitable prices?
I think the distinctions have to be drawn on several levels, Your Honor. First of all, in the Yakus case, the court recognized in dealing with price controls that it had an understanding from the previous price controls in World War I and adjudication of those cases what a fair price would be. I think the second distinction, however, is that the undertaking to discover what is a fair price is of quite a different order than the undertaking to decide what is a fair sentence. The price...
Doesn't the court give quite a few guidelines in terms of what the commission has to look to? For example, a sentencing range in each category within certain percentages of the maximum sentence and so on and so forth? Seems to me that's more precise than the standard in the Yakus case.
There is a part of the statute where it is much more precise, and that is in a small category of cases, I think about third-time violent crimes or drug offenses, should get a sentence at or near the maximum. But for most cases, and that...
Well, would you in that case then validate the standards as to those offenses and and set aside the balance of the standards?
No, I think that Congress intended the guidelines to be implemented as a whole, and I wouldn't set aside just those. But I think that that special provision indicates that Congress really had no idea on the questions the Commission was going to face, what it should do. The Commission had to decide whether sentences should be harsher or more lenient, whether a sentence should reflect the purpose of retribution or rehabilitation. You look at the questions the Commission had to face, and you almost want to ask, where was Congress? And the answer would be, Congress was nowhere to be found. It was the Commission that had to make these decisions. And those are the types of fundamental legislative decisions that our Constitution says must be made in Congress itself.
Counsel, it's been a long time since this court has invalidated anything on the grounds that Congress has made an excessive delegation. How would you distinguish this case from the myriad of cases where Congress has delegated the power to decide what's in the public interest in communications, what's a fair trade practice, any number of other situations where vast power has been delegated to the executive agency?
I think that there are several factors this court ought to look at in finding this delegation special. First of all is the repeated pronouncements by this court of how central a legislative function criminal punishment is. As recently as the Whalen and the Rommel cases, the court noted that those questions are peculiarly ones of legislative policy. I think it's further distinguishable because when a society is imposing punishment, it is society acting as a whole, expressing its will. And this court has also found that Congress is the voice of the community when that will is expressed.
But you have just said, counsel, that it's perfectly okay for an individual judge to make enormous discretionary decisions within the same contours that the Sentencing Commission did. And as we all know, judges are totally unelected, and some people would even suggest not always totally responsive to the the changing democratic mores. So how do you take that into account?
I don't think the fact that our Constitution envisioned a judiciary, which by its nature is unaccountable, means that Congress has carte blanche to farm out its duties to unaccountable branches. The Article 3, recognizing the unaccountability of the judiciary, strictly limited the types of duties it would do.
One of those has always been to pick between within large ranges of sentencing.
Certainly, Your Honor,
So
but never.
Congress could give an individual judge that power, but it can't give this commission that power.
And I think that is the idea behind Article 3. Limited to a case or controversy, a judge must enter a judgment. But a judge cannot, because he or she is able to enter a judgment, therefore go out and make prospective policy decisions on all of sentencing. Those decisions are the types of legislative decisions we have Congress do. So a judge is not making policy. A judge, although he or she had discretion, isn't making policy. And the policy decisions are what the commission is making.
Mr. Lawson?
Yes.
How would you distinguish the parole commission?
I see my time has run out. Could I have the time to answer that question? Thank you. Oh, I'm sorry, I misread. The Parole Commission, I think, is distinguishable on the factors that we've listed in our brief. First of all, this court has never intimated that Congress must regulate the parole policy itself, nor has Congress ever been terribly active in it, as it has in sentencing. Secondly, there is not a fundamental right involved. The mere creation of a parole commission does not endow a prisoner with a constitutionally cognizable liberty interest. This court noted in Greenholz the crucial distinction between being deprived of liberty one has, as in sentencing, and an expectation of liberty one does not yet have, as in parole. Only the former is protected.
As a practical matter, the parole commission had more authority with respect to the term one actually served than the district court judge. Do you agree with that?
Yeah, the Parole Commission could make the decisions later and would have more discretion over that, yes,
So
certainly.
in the end, the time anyone convicted of a crime and sentenced to prison would remain in prison was determined by the Parole Commission.
Certainly, Your Honor. But there is...
Far greater authority than the district court judge in the end had.
And in that respect, but I don't think the inquiry is just the sheer length. And under that circumstance, the pardoning power would also undermine the judge's power in imposing a sentence. But the distinction here is that the policy questions of parole have never been supposed to be one, although they may be substantial, have never been supposed to be one exclusively for Congress. In fact, some district courts, including the Brody Court cited in our brief, have held that the Parole Commission is not a delegated power at all, but derives from the President's pardon and clemency powers. So in that respect, there may not even be a delegation issue at all.
There's a Third Circuit case, I don't remember the name of it, which sustained the validity of the Parole Commission and indicated that it did have very extreme authority.
I think that would be the Garrity case, Your Honor?
Yes, that's right.
Yes, but in either case, I don't think this issue can turn on the extent of the power. Rather, it should turn on the extent to which policy in sentencing, which this Court has articulated, must be made by Congress itself. I see my time is up. Thank you. Mr. Chief Justice, and may it please the Court, my name is Mayor Fetter, and I also represent Petitioner Samuel Rathburn in this case. My colleague, Mr. Rochman, has just explained how the Sentencing Reform Act unconstitutionally delegates legislative power to the Sentencing Commission. I will now discuss why the Act is unconstitutional, not only because Congress may not delegate this power over sentencing, but also because of to whom Congress has delegated this power, to the judiciary. Under the scheme of our Constitution, and in particular Article 3 of the Constitution, judges may not be lawmakers. But in the Sentencing Reform Act, by requiring the Commission to make binding sentencing rules, Congress has imposed upon the judiciary just such a forbidden substantive lawmaking power. The constitutional flaw of the Act is thus a straightforward one. It violates Article 3, which has stood for 200 years both to constrain and to preserve the role of the judiciary in our constitutional system.
How do you accommodate our recent holding in Morrison versus Olson? Would you not interpret that as a slightly more flexible approach to what the judiciary can do? In that, as you will recall, it was decided that indeed a special branch could appoint special counsel and even define their jurisdiction and do a limited extent of monitoring. Against the argument, we upheld that law against the challenge that the appointment of prosecutors and the prosecutorial function was quintessentially an executive function.
Well, Your Honor, there are a number of things that this Court did uphold as assigned to the judiciary in the Morrison case. The appointments power was upheld as consistent with Article 2, Section 2, Clause 2, and so, like Article 3, which is the main source of judicial power in the Constitution, the appointments power can be vested in the courts by the express terms of the Constitution. The Court also took pains to note that the Special Division of the District of Columbia Court of Appeals in that case had no power to supervise the independent counsel in the exercise of her executive activities, but rather that the activities of the Special Division in that case were either passive or purely ministerial. And the Court took pains to note both that these activities were within what is permissible under Article 3 and did not permit any departure from Article 3, and also took pains to note that other activities that the Special Division may have performed in other cases would raise serious constitutional doubts. And so the Court was very concerned there with the constraints of Article 3. The other important distinction from the Morrison case is in the types of powers involved there. The very limited nature of those powers is a very good example of why this case is different. What is involved here is the power essentially to make substantive law. And the power to make such law is about as far removed from the permissible judicial function as anything can be under our tripartite system of government.
The Sentencing Commission is laying down, quote, guidelines. If a judge wants to go outside those guidelines under the statute, he's permitted to do so if he makes an explanation, which can then, of course, be appealed to a higher court. And overall, if Congress doesn't like what the Sentencing Commission has done, we can assume it can pass a specific statute undoing any part of that. So is this really a massive invasion either of the judiciary or, as your colleague said, of Congress's power? Or is it just one of those coordinating devices which separation of powers has to have in order to be able to allow the Constitution to move with the times and to meet new problems?
Well, as to the binding nature of the guidelines, just 2 terms ago in Miller versus Florida, this court faced a similar state scheme and held in that case that although a Florida district judge under the Florida guidelines could depart from the Florida guidelines if certain findings were made, that this did not mean that the guidelines were merely procedural devices to guide the judge's discretion, but rather that they were substantive in that they created what the court called a high hurdle that had to be overcome before the guidelines could be departed from. And in fact, the Sentencing Commission, in its preface to the guidelines, noted that it expected them to be binding in 90% of federal criminal cases. And so these guidelines are, in that sense, binding substantive law, and that is a point on which I believe this court's opinion in Miller is binding, in that these are not mere procedural guideposts, but rather impose a sentence. As to the fact that Congress may, in fact, change the guidelines if it desires to pass a new law, that is certainly the case, and there is no contention that the Commission is given unreviewable authority in the sense that Congress may not always overturn what the Commission has done. However, this ability of Congress to pass a new law is something that always exists whenever there is any delegation of legislative power to the executive branch, which is to where legislative power is normally delegated. And so the power vested in the judiciary by this act is equally a lawmaking power as the rulemaking vested in the executive branch in many cases.
Would you agree with me that the statute involved here does not involve self-aggrandizement by Congress?
In the strict sense, no, Your Honor. There is, in some sense, an aggrandizement by Congress whenever Congress is able to impose on another branch duties that may weaken that branch, and certainly whereas in this case there are indications that Congress has delegated that power because Congress was unable to make the legislative process work itself, and so has tossed it over to another branch because it was too difficult to be dealt with in Congress. But as you suggest, this is not a congressional aggrandizement in the sense that such cases as for instance, Boucher or Chadha would have been.
Well, if that's the case, then don't we have, as your opponents claim, a different standard in looking at this legislation than otherwise?
No, Your Honor.
In other words, what your opponents call a functional approach.
Yes.
Is there such a standard?
Yes, such a standard exists and was articulated by this court first in Nixon v. Administrator of General Services.
All right, then I'd like to know how a pragmatic analysis under that standard would impair the performance of the judiciary branch.
The impairment in this case would come from a number of sources. The prime impairment would come from the fact that this vests a legislative power in the judiciary, and
on 3 members of the judiciary.
3 members of the judiciary, but in the judicial branch. And
you mean that taints the rest of the branch somehow?
Yes, Your Honor. It taints the rest of the branch because the limited role of the judiciary in our system and its independence of the political branches is important in a number of ways. One of the most important is simply for there to be public confidence in the judiciary. The judiciary must not be involved in the type of naked policymaking at large that is required by this case or by anything vesting lawmaking power in the judiciary.
But isn't the public accustomed to having judges deal with sentencing?
Yes, Your Honor.
Well, why is this different?
Well, because there are many things.
As far as the public is concerned.
Because what is going on, as my colleague referred to, in an individual sentencing case, is that a judge is performing the judicial case or controversy function and is seen to be deciding a particular case in accordance with the law as it stands. What happens in this case is that the judiciary is required to engage in policymaking at large and is required to act prospectively, to issue rules that are binding and not in the context of a case or controversy. And in fact, the difference between these is one that is recognized by our Constitution in other contexts. For instance, the rule against advisory opinions prevents this court or any other court from issuing an opinion as to the constitutional validity of a statute. And yet, at the same time, this is something that courts can do within the context of individual cases, and in fact, as you are in fact doing in this case. And so the way the Constitution limits the role of the judiciary is not by any particular limit that is aimed at saying no judgments can be made that are not expressly in a statute, but rather by making the judiciary a passive branch that acts in general only when faced with a case or controversy. And so the differences between the two situations are recognized both by the Constitution and, I would think, by the public at large.
What is the difference between this situation and the federal rules situation, which we've been very much at home with for many, many years? Now, I hope you won't tell me that one is procedural and the other is substantive, because all of us who have worked on both sides of the bench realize how much substance there is and controlling outcome controlling principles in the federal rules. But yet we've had a mechanism which is not that different. A mixed committee which recommends them, and then the court eventually comes out with them, but they do define uniformly for all federal litigation, not on a case-by-case basis.
Well, I'm afraid I'm going to have to disappoint you, Your Honor. The difference is that those rules are procedural and these rules are substantive.
You have disappointed me, counsel.
And as this court has quite rightly noted in passing upon the validity in various cases of individual federal rules, the fact that a rule is outcome determinative does not mean that it is substantive, because as I think Justice Harlan pointed out in his famous concurrence in the Hanna case, any rule, if enforced, is outcome determinative. And the important inquiry, rather, is one that this court pointed out in Mississippi Publishing Corp. Versus Murphy, where it made a distinction between imposing rules that have incidental effects on substantive rights but yet aim merely at governing the procedure of the courts, and that of imposing rules of decision. And that is the distinction that is operative in this case. The types of rules that have been upheld as federal rules of procedure, and the statute, of course, contains an express limitation to procedural rules, and so the court has not had to address the difference between the statutory and constitutional standards, simply because as long as the rule is procedural within the statute, the constitutional standard is the same, substance procedure.
May I just interrupt you there? The distinction you're trying to make between procedural and substantive rules, wouldn't you say that with respect to the rules of civil procedure, for example, that Rule 23 that I think deals with class actions is
Yes, Your Honor.
quite substantive?
Well, Your Honor, I think that perhaps it is substantive in the sense in which Respondent uses the term substantive, which means that there are effects that are different from the effects that you would get from rules, say, mandating what type of paper must be filed in courts or what color the covers of briefs would be. However,
A class action brings into court, almost as if it were a small claims court, hundreds and hundreds of people who otherwise couldn't get into federal courts at all.
yes, Your Honor. However, it does not create for them new rights that, or duties for that matter, that are not already existing as positive law.
But they had no opportunity to exercise them.
Well, there was the opportunity generally to exercise those rights in state court. Further, I believe that the distinction here is, again, something that Justice Harlan referred to, which is whether a rule will affect decisions of primary conduct as opposed to merely decisions of litigation conduct. And the problem in this case, Your Honor, is that the rules here, the sentencing rules, will affect primary conduct by creating a specific sentence that will apply for almost any individual offender or particular crime. And the way in which these rules affect primary conduct can be analogized to other possible rulemaking responsibilities that Congress might choose to impose on the judiciary if judicial rulemaking were considered permissible in this case, because once the substance procedure and the judicial lawmaking distinction is broken down, and once courts are permitted to make law, as Respondent urges that they be permitted in this case, there really is no particular limitation point available. And so courts might make prospective and quite comprehensive prospective rules in antitrust cases, securities cases, whatever Congress might decide to dictate. And these would be tested only against whether, under Respondent's approach, against whether there would be any concrete impairment that could be shown in an individual case. The framers of our Constitution took quite the opposite position, and they set up Article 3 as a self-executing structural safeguard to prevent the judiciary from departing or being forced to depart from the judicial role. And the Council of Revision, for instance, that was rejected by the Constitutional Convention, which would have given some judicial members, in conjunction with the executive, a veto power over congressional legislation, was rejected in large part because that would have made judges into lawmakers. And so for 200 years, dating back to the Constitutional Convention, and right up till today, this court has set its face against permitting any sort of judicial lawmaking in the sense in which it is imposed upon the judiciary here. I see my time is up. If there are no further questions. Thank you.
You may proceed.
Mr. Chief Justice, and may it please the court, my name is Robert Miller. I, along with my co-counsel, Mark Nielsen, represent the respondent in this case, the United States. We will present the reasons why this court should affirm the Court of Appeals in its holding that the Sentencing Reform Act is constitutional because it neither violates the separation of powers nor the non-delegation doctrine. In particular, I will show that the power to promulgate sentencing guidelines is delegable and that Congress effectively delegated that power to the Commission. When it delegated sentencing power to the Sentencing Commission, Congress acted in accord with all past cases and principles in the delegation area ever expounded by this court. This court has never found any power to be per se non-delegable. Although some powers may be non-delegable, the power to promulgate sentencing guidelines is clearly not among them.
Could Congress delegate to a commission like this the power to define crimes itself? Suppose it said, listen, things are getting very complicated now with new technological age, and we don't really have the time to get into computer fraud and international markets frauds. We're going to set up a high-power blue ribbon commission. They can just define the elements of computer fraud or other crimes, and the courts will apply it. Different or the same, and why?
That presents a very different case from this one, because that may well be a non-delegable power. As I said, this court has never found any powers to be non-delegable.
Why would defining the crime, why would we know instinctively, certainly the Constitution doesn't tell us by reading it, why would we instinctively think that's no good, but defining what sentence goes with what crime is okay? For the vast majority of defendants, it's much more important what the sentence is than the crime, since over 90% plead guilty to whatever they're indicted for to begin with.
Congress has not merely delegated wholesale powers in the sentencing area to the Commission. It has defined the crimes, and it has set the maximum and the minimum, and it has merely delegated the power to an administrative power to fill in the gaps that Congress has decided it does not have the expertise or the time to create itself in this area. It has not granted wholesale powers to the Commission. Furthermore, Congress has delegated sentencing power in the past, for example, to the Parole Commission, as Justice Powell pointed out. The Parole Commission set the actual release dates for most prisoners in the federal system, and so in a very real sense, it was delegated a great deal of power to determine sentencing policy. Under the former sentencing regime, judges would set the initial sentence, and then the Parole Commission could set an actual release date after a defendant had served 1/3 of his sentence. This court acknowledged the great power of the Parole Commission in the sentencing area in United States v. Grayson and United States v. Adonizio. Although the court did not directly confront the delegation problem in either of those cases, it did refer approvingly to the activities of the Parole Commission and, in general, to the ability of other branches to exercise power in the sentencing area. And again, as Justice Powell has pointed out, the Third Circuit in United States v. Garrity relied on the decisions of this court in Adonizio and Grayson to hold that the delegation of sentencing power to the Parole Commission was in fact constitutional. While the Parole Commission did not exercise the great breadth of power entrusted to the Sentencing Commission, it certainly did exercise delegated powers over sentencing. The only substantial guidance given to the Parole Commission by Congress was that its decisions be consistent with public welfare and not depreciate the seriousness of the offense, certainly much less direction than Congress has here given to the Sentencing Commission. Also in parallel with this case, the Parole Commission had its own set of guidelines which set release dates within the statutory maximum and minimum set by Congress for all federal crimes in which prisoners served more than 1 year. These guidelines were similar to those created by the Sentencing Commission, and in fact, the Sentencing Commission looked to those guidelines as one of its models for its own set of guidelines, which are here being reviewed. Contrary to Petitioner's contention, Congress may delegate a power over economic regulation or over individual rights. This court has applied the same standard to all cases. For example, in Hague v. Agee, this court reviewed and approved a congressional delegation of power to deny a citizen the right to travel, a fundamental right. That case did involve national security concerns, but the ability to delegate powers over fundamental rights is not limited to national security concerns. Congress consistently delegates powers over fundamental rights to administrators, commissions, and the executive branch. For example, the FCC is delegated the power to determine what constitutes offensive language in broadcasting, which potentially limits First Amendment rights.
What kind of a principle would you try to persuade us to adopt to put some limit on it? You're now saying that we have all of these big examples of delegation of administrative agencies, the Parole Commission, which you suggest closely parallels the Sentencing Commission. Is there in fact any limit, and if so, what is it, on Congress's power to delegate what might be looked at initially as a legislative policy decision to either the executive or in some cases, the judiciary? Does anything go?
Well, as I said, this court has never confronted such a problem. There's no line drawn in this area.
We might have to confront it in this case. So are you going to advise upon us any principled decision, or shall we just say, well, this isn't it, we'll wait till one comes along?
No, Your Honor. One principal distinction would be between rulemaking functions and non-rulemaking functions. For example, one commentator, Professor Tribe, has suggested that the power to impeach could not be delegated. That's a power specifically vested in Congress with procedure given in the Constitution on how
So is the
Congress
power
should...
to make laws specifically vested in Congress, too. But you're suggesting that for all practical purposes, a lot of that can be delegated and has been delegated in the past. I'm only asking you, is there any limit, and if so, what is it?
Well, the absolute limit would be that Congress cannot delegate its own powers. It can delegate rulemaking powers, administrative powers, such that administrative agencies can formulate such rules and not make legislative policy decisions. In the area of individual rights, this court has in the past narrowly construed congressional delegations where they were not clear and unambiguous, because it felt that Congress could not unintentionally delegate such powers. For example, in Kent v. Dulles, which dealt with the same statutory authorization as in Hague v. Agee, this court held that Congress did not clearly and unambiguously delegate that power. But there can be no question in this case that Congress specifically and unambiguously delegated the power to promulgate sentencing guidelines. That's precisely what the Act was all about. Moving on to the standard, Congress need only provide an intelligible principle to guide the Commission's exercise of this power. That is all this court has ever required for a delegation to be constitutional. Congress must lay out its legislative purposes and the means of achieving them with enough specificity so that the Commission can follow congressional intent, and so that courts have a standard against which to judge the exercise of that delegated power. In the Sentencing Reform Act, Congress amply provided such an intelligible principle to direct the Commission in formulating guidelines for judges to use in sentencing in federal criminal cases. While individual justices have from time to time proposed alternate standards or formulations, this court has consistently seen that no more rigorous test of delegation is necessary or even desirable. Again and again, in many different contexts and cases, this court has applied the intelligible principle standard as the sole standard in how Congress should delegate powers. The reason that the intelligible principle standard uniformly applies to all delegation cases is because it embodies the core value protected by the delegation doctrine, accountability. Congress, the body of government most directly accountable to the people, must make those fundamental policy choices which serve to govern our nation. And in this case, in the Sentencing Reform Act, Congress has clearly made those fundamental policy choices. In the Sentencing Reform Act, Congress's fundamental policy choices were to reduce unwarranted disparities in sentencing, both between different offenders who committed the same offense and are equally culpable, and between different offenses which cause equal harm to society. Another fundamental policy goal that was articulated in the Act by Congress was to systematically incorporate community values in the sentencing process, both to provide community input in a regular and systematic way, and to make sentencing an evolutionary process, such that penological and judicial advances could regularly be incorporated. I'm Mr. Miller, Your Honor.
I'm interrupting you in the argument, but in your brief, you argued, as I'm sure I would, that there hadn't been a delegation case invalidated since 1935, 50 years. You made that argument, didn't you?
Yes, Your Honor.
I'm old enough to remember the sick chicken case in 1935, when the NLRA, I think, was invalidated. But has there ever been a delegation case since then that was fairly comparable to the case we're arguing here this evening in terms of substantive rights and provisions?
No case is exactly on all fours with this case, but in Yakis v. United States, for example, Congress delegated very broad powers to regulate the national economy, to set all prices, wages, commodities, and rents throughout the economy, and gave very little standards on how that power should be exercised. So I believe there's a comparable breadth of delegation, and the standards given by Congress in that case were much less than in this case. Those standards include methodological guidance, specific directions on certain provisions in sentencing, and continuing control by Congress. As far as methodological guidance, Congress still, as I said, sets the maximum and the minimum sentences and defines all crimes. It has also directed the Commission to come up with a matrix of offense and offender categories, such that for every coordination of offense and offender categories, there would be one specific sentence. In this case, to illustrate, I believe, Justice Powell, you asked a question on how that would work in this case, and I believe that Petitioner has misapplied the guidelines to heighten the discrepancy between the sentence that Judge Pritchard has given and the actual sentence that the sentencing guidelines would afford. There is a base sentencing level for the offense of counterfeiting, which Petitioner was convicted of 9. That level can be increased to 15 if there is a particularly egregious case of counterfeiting that the defendant controlled the counterfeiting mechanism. Then the judge can reduce that level by 2 to 4 levels if he finds that the defendant was only a minor participant in the crime. That level can be reduced by a further 2 levels if the Judge Pritchard, found that defendant admitted his guilt. That would result in a net sentencing level of 3 to 9, and the offender level would be the first column of, as you can see, it's a very complicated system, and that's why they delegated to experts to figure out the workings. But I mean, just to explain in brief, there could be probation in this case, and there's a great deal of judicial discretion allowed in exactly where each individual defendant would fall in that chart. And Congress had to delegate that power to the Commission because it was very complicated and required a great deal of research. As far as the specific directions, Congress has directed that maximum sentences be given for some egregious offenses, such as violent crimes, recidivists, and certain serious drug offenses. It is directed that substantial sentences, be given for professional criminals and RICO offenders. And on the other hand, it is directed that lenient sentences be given to first offenders and those who aid the prosecution in other cases. Furthermore, there is continuing congressional control over the sentencing process through the requirement of annual reports by the Commission, both for the first set of guidelines and for every continuing set of guidelines thereafter.
Do the guidelines authorize capital punishment?
No, Your Honor, they do not. That power was not delegated by Congress to the Commission, and if it had been, it might present very serious problems, as this Court has recognized in previous cases, because there's an independent Eighth Amendment concern, as this Court noted in Woodson v. North Carolina.
Congress couldn't delegate the power to declare war, could it?
No, Your Honor, that's another instance that Congress probably could not delegate powers in. A further control that Congress maintains over the sentencing process is that the 180-day report and wait procedure, such that Congress is not merely granting total discretion to the Commission and that Congress probably could not delegate powers in. A further control that Congress maintains over the sentencing process is that the 180-day report and wait procedure, such that Congress is not merely granting total discretion to the Commission and retains no control. Congress, after it gets the sentencing guidelines from the Commission, has 6 months to review them, and if there's anything in there that is beyond congressional intent, then those factors will be looked at it by Congress and perhaps overruled, or statutory authorization will be revoked.
The President doesn't get to pass on that, does he? It doesn't go back to the President for signature.
If Congress passed an act revoking discretion from the Commission, then that would have to go before the President because of the requirements of CHATA, that there be bicameral passage and presentment to the President. So this case fully meets the requirements of CHATA, that if any discretion were to be removed from the Commission, which is really more closely analogous than discretion removed from the judiciary, as Petitioner contends, then CHATA would have to be carried forthwith. There's also this court's power to review the Commission, and all courts' power to review the Commission's actions as far as continuing controls to make sure that it acts within statutory guidance. As Justice Powell pointed out in the capital punishment area, that might be one instance where that discretion might be exercised. Finally, I see that my time is up. If this court has no further questions, I would urge it to uphold the decision of the Court of Appeals that the Sentencing Reform Act is constitutional because the power to promulgate sentencing guidelines is delegable, and because Congress provided ample standards to meet the intelligible principle test as set forth by this court. Thank you.
Mr. Bellow?
Hey, Your Honor, I'm Mr. Nielsen. Mr. Chief Justice, and may it please the Court, I will present the reasons why Petitioner's separation of powers argument is also without merit. Your Honors, in recent cases, this Court has clearly commanded that the requirements of Article 3 and the separation of powers doctrine in general are to be interpreted flexibly and pragmatically in cases like this one. As a result, neither of the Commission features that Petitioner focuses on, neither the Commission's rulemaking power nor its alleged involvement in political decision-making, give rise to a constitutional defect in the Commission or the Sentencing Reform Act.
Isn't one of the criteria that we've laid down in some cases, especially in so-called non-aggrandizement cases, whether or not the functions that are given are inconsistent with the role or even the perception of the role of the branch to which they're given? Now, let me just ask you for your reaction to a situation where the President appoints some Article 3 judges to a commission. He also, in making that appointment, they are in the minority on that commission, and he has to ensure that only 4 out of the 7 of the total members of the commission are from the same political party. Hence, he has to at least look at the political party of the judges in order to decide whether they'll fit into the total framework. And on top of that, the President is allowed to remove one or all, presumably, of those judges from this commission for cause. Now, that cause, I suppose, could be negligence in performing their duties on the commission, maldiction, maybe he finds them in flagrant delicto, whatever the phrase is, on something, and he then removes them. Now, isn't that a very troublesome relationship between the executive and an Article 3 judge, which is supposed to be quite independent of the executive?
Your Honor, the pragmatic standard employed in Article 3 cases and in separation of powers cases looks to whether the institutional relationship, the authority structure, undermines the ability of any branch to serve its constitutional function. Now, one of the ways that the judiciary's function could be undermined, its constitutional adjudicative function, would be if there was too close a relationship established between judges and the policies of one of the political branches, the President in your hypothetical. The way I would distinguish this case is by pointing out, Your Honor, that there is no political mission that this commission is serving. Unlike the President's Organized Crime Commission, which was recently in place. This commission is vested with no political mandate, has no pro-prosecution bias. Quite to the contrary, its chief task is the formulation of guidelines that serve to eliminate unwarranted disparities in sentences.
But in the process, counsel, most of us are realistic enough to realize that in terms of defining which crimes incorporate the highest community values, which crimes are to be perceived as the most serious, from the point of view, it becomes intensely political. If an administration is on a drug enforcement bent, surely it will want its appointees to place high priority on the punishment of drug crimes, on the punishment of terrorism, on the punishment of particular kinds of crimes that it considers very important. How can that commission really be divorced from the political arena in that sense?
Your Honor, there's no way that a commission could formulate guidelines that would eliminate sentencing disparities without exercising some amount of discretion.
Exactly.
However, the statute is quite clear in saying that the overwhelming function, the primary function of this commission, is simply to eliminate unwarranted sentencing disparities. Furthermore, Your Honor—
That's the goal, but the means is left very much—
Well, Your Honor, the means, one indicator of the lack of constitutional defect in the means is the fact that this commission started with empirical data. It looked to what sentences were across the country and sought to come up with averages and proceeded in a very cautious way from those averages. Moreover, I think further evidence that this commission does not have the sort of pro-prosecution bias which you hypothesize, is that it was enacted into law and established by an overwhelming bipartisan majority of Congress. There were very few no votes when this act came up before Congress. It was supported by members who would not agree with administration crime priorities, as well as those who would. I'd like also to address, Your Honor, the point that you made earlier with regard to the President's removal power and his appointment power. Now, first, with regard to his appointment power, I should point out that it's not an unchecked power. The judges that the President selects are from a list forwarded to him by the Judicial Conference.
Do they have to look into the politics of the judges before they name the members of that panel?
If I understand your Honor's question correctly, there is no requirement that the President look into the judge's perspective or philosophies. He's given power to pick any three of the members of the judiciary that are the list forwarded to him by the Judicial Conference.
Now, could the Judicial Conference name justices of the Supreme Court?
I believe that there's no restriction in the statute that would keep them from doing that, Your Honor.
Well, is there anything in the Constitution that would prevent justices of the Supreme Court to sit on this commission?
No, Your Honor, I don't believe there is. If we look to history, justices of the Supreme Court have sat on commissions assigned with non-adjudicative functions. Justice Stewart—
Have any of them sat on any commissions with a legislative power?
No, Your Honor, I don't believe that justices of the Supreme Court have sat on commissions with rulemaking power, although I could present to you—
Is there a difference between rulemaking and legislative power in this respect?
I don't believe so, Your Honor. I would point to the United States Supreme Court, this court's ability to promulgate the federal rules of civil procedure as an instance in which judges have participated in rulemaking. But to return to your question earlier, Justice Wald, about the removal power, I wish to point out that the President's removal power is for cause, and it's important to note that his removal power does not go to the judges in their capacity as judges. It simply goes to their capacity as commissioners.
I understand that, but what's the perception of an Article III judge who has been removed by the President for cause from the commission? I know that he or she goes back and sits on their court, but isn't there usefulness, isn't their perception very much impugned?
I would agree with Your Honor that the aspect of this case to focus upon is whether the President's removal power causes the judiciary's ability to perform its adjudicative function to be undermined. However, the pragmatic standard commands attention not to unlikely possibilities, but to realistic threats. And I believe that the fact that the President's for-cause removal power is precisely that, for cause, takes away the threat that it will be used in such an aggressive manner so as to undermine the judiciary's perception of being unbiased and independent.
Could a judge who sat on this commission sit on a panel passing on the constitutionality of this statute?
Well, Your Honor, given that this court in these proceedings is to pass on the constitutionality of the statute, I believe that that is not a prospect which will arise.
Well, I ask that question because I think there's a difference between knowledge acquired judicially and extrajudicially. Now, that's the difference why, for example, in the case of the rules of procedure, which is passed upon by the Supreme Court, the judges would not be impeded from sitting and passing upon a challenge to any particular rule. Now, would that be the same situation in this case?
Well, it would be the same situation, but if this court rules on the constitutionality of the Sentencing Reform Act and the Commission, I believe it's a question which will not arise again.
Well, let me ask you a follow-up. What about one of these three judges sitting on a case, he finishes the term, goes back and starts sitting on his court again, and say it's an appeal court, and he gets one of these departure cases where some trial judges said, gee, those guidelines, they just don't fit the bill in this particular case, and I'm departing from them because I think they're dead wrong, and here's all my reasons why I'm not following them. That be a recusal situation?
I don't believe so, Your Honor, for the reason that I don't believe that allowing a judge to both have a hand in the creation of the guidelines and to confront them in his later or her later judicial duties.
It's a lot of judicial restraint, wouldn't it?
Your Honor, I believe that it would not give rise to any sort of undermining of the judiciary's appearance of impartiality and independence, which is fundamental to its ability to serve its adjudicative function. I should point out, with regard to the President's for-cause removal power, that there are other contexts in the government where for-cause removal power is not seen to create constitutionally defective subservience in the officials that are removable. The United States Tax Court, as we pointed out in Respondent's brief, whose judges are removable for cause by the President, is just such an example. And in fact,
Article 1 court, isn't it?
It is an Article 1 court, Your Honor. But Petitioner's argument is that removal power by the President over an official in a different branch gives rise to constitutionally defective subservience in the removable official. Now, the fact that this is an Article 1 court, the United States Tax Court, doesn't serve to take it away from the principle that subservience, constitutionally defective subservience, does not always follow.
Well, didn't we worry a lot about that in the Sinar case, the fact that Congress could remove the Comptroller General when he was performing a so-called executive function? I
think Boucher v. Sinar, Your Honor, is distinguishable quite clearly for a couple of different reasons. Number one, Boucher v. Sinar is precisely and quintessentially a case in which Congress aggrandized its own powers by taking the action of assigning important executive functions to one of its agents, the Comptroller General. Therefore, it is quintessentially a case in which Congress aggrandized its own powers, and therefore it triggers the strict separation of powers analysis that the court subjected it to in that case. Here, there is no power grab going on by Congress, if you will, and therefore this pragmatic standard is called for. The Boucher case, Your Honor, is also distinguishable on its facts. There was a history of subservience, a history of the Comptroller General being an agent of Congress. Here, by contrast, the history is precisely the opposite. Judges have been independent and impartial and removed from the President's power, and they remain removed in their capacity as judges under this act.
Counsel, I'd like to go back to the nature of the work of the Commission. I'd like to know if the best case you have, the best situation in which there has been a commission or there's been a group of judges whose primary function is rulemaking.
Well, Your Honor, I think that
Is there any other function than rulemaking in this case?
I think that rulemaking is what's at issue, and I think that my best example is the United States Supreme Court's power to promulgate rules of civil procedure. And as Justice Powell pointed out earlier,
But that's not the only function of the Supreme Court, is to pass rules. That's a side function, secondary function. It's almost an inherent right of the courts.
well, that power was vested in the court by the Rules Enabling Act, an act of Congress. But I would point out that the function of these commissioners is mainly as judges, and that this is just a side ancillary function for them as well. Petitioner seeks to point out the fact that judges cannot act as lawmakers, but clearly this is not a fact. Judges make substantive rules in many contexts. Whenever the court is deciding a case where substantive federal common law is applicable, it creates substantive rules.
So you're saying that the functions that perform, the judges are performing here are within their functions as Article 3 judges?
Yes.
The same as the rules?
Your Honor, the flexible approach...
Excuse me, can you just answer that question first? Because I have a follow-up question.
Could you repeat the question for me, Your Honor?
Are you saying that the function that is being performed by the commissioner judges is within their Article 3 duties?
Yes, Your Honor.
So you were saying, in effect, that if the judges that are appointed refuse to serve on this commission, they would be in violation of their oath of office?
No, I don't believe so. They are free to do that, Your Honor.
Supposing all the judges refuse to sit?
In that unlikely circumstance, I would assume that the commission could not function. But again, the pragmatic standard calls for attention not to unlikely theoretical possibilities, but it calls for attention to realistic possibilities. Your Honor, the fact that this commission has judges on it does not give rise to any sort of defect in the judges' impartiality and independence, and that's why it is not outside of their ability to do under Article 3. The pragmatic standard to Article 3, commanded in such cases as CFTC v. Shore, clearly commands that judges may engage in duties, non-adjudicative duties, so long as they're not undermined in their ability to serve their constitutional adjudicative function. Moreover, Your Honor...
Does that mean, I hear the words you're saying, counsel, but I'm trying to figure out, maybe it's another unlikely hypothetical, but where those words will take us. It sounds as though you're suggesting that if you've got a high-powered judge who can finish his caseload, then he can be appointed to any commission that the president would like to have him on. Because it isn't going to interfere with his duties. He's drafting his opinions. He's up to date on his caseload. And so the president can put his favorite judges. The president can put his favorite judges on all sorts of goody commissions out there.
Well, Your Honor, as a
No,
first...
I'm asking for a principle that we can apply that I know you would say, no, that's not right, but I'm trying to figure out what the principle is, and the principle has to be something over and above the fact that it won't interfere with the way he performs his daily duties.
Yes, Your Honor, there certainly is some line to be drawn, and I think it's difficult to identify what it is. But a number of recent cases have indicated that Congress's ability to assign non-adjudicative tasks to courts, rulemaking tasks to courts, somehow involves the principle that those rules must be involved with the regulation of court-related activity. I would point to the Morrison case recently, in which this court approved the vesting of certain supervisory powers over the special prosecutor in a division of the D.C. Circuit, and approved those powers because they were related to traditional judicial functions. Moreover, the recent Young v. United States case approved the power of certain courts to subpoena witnesses that case involved the power of the court to appoint private counsel to prosecute criminal contempt cases, and this court stated that case, that power was to be approved because it involved the ability of judges to maintain respect in the judicial office. The third case that I'd like to point to, Your Honors, is the recent 11th Circuit In Re Certain Complaint case. That case involved the vesting of power in judges to subpoena witnesses. It was a committee of the Circuit Council of the 11th Circuit, and power was vested in that committee to subpoena witnesses with regard to a case involving judicial misconduct. I think that although the line is difficult to draw, it has something to do with the rules that regulate court-related activity. But my fundamental point, Your Honors, is that that line is not approached in this case. It's clear.
If they're dealing with court-related activities, why is it that the minority of the members are judges? Doesn't that do something to the judicial function, if it is part of the judicial rulemaking function?
Your Honor, I think that I would not look behind Congress's thinking as to why a minority are judges.
No, but that makes a distinction between this situation and the rules. The rules are all passed by judges. And in this case, you compare that the situation to the rulemaking, yet the legislation of these guidelines takes place with a majority of non-Article III judges.
I think that that fact would only have significance, Your Honor, if somehow it associated the judges too closely with the political agenda of one of the political branches. The service of non-judges on this commission has no constitutional significance, Your Honor, the government argues, because it does not serve in any way to taint the judges or the judiciary in their adjudicative function. The fundamental point which I wish to make, Your Honors, is that this court has long accepted many innovative government institutions and authority structures. It has accepted legislative courts, executive rulemaking agencies, and this court's power to promulgate rules of civil procedure, just to name three. It has not agreed with Petitioner's argument that the most nominal mixing of functions, the most innocuous blurring of the lines between the branches, gives rise to a categorical, unconstitutional ruling in a case. Your Honors, the Sentencing Reform Act serves important purposes, and it does not assign unchecked powers to any branch. Moreover, it does not undermine the judiciary's ability to serve its functions. I would therefore urge the court to uphold it.
Thank you very much.
Your Honors, just a few very quick points. Taking the latter argument first, on the separation of powers argument, as to the standard, in support of Respondent's claim that this court has consistently applied what it terms a pragmatic standard to Article III cases, Respondent is able to cite only one case, which is the CFTC versus Shore case. What that case involved was not any imposition on the judiciary of non-judicial functions. Rather, that was a question of whether an administrative adjudication in the executive branch violated Article III by trenching on the judicial responsibilities of the judicial branch. And so in support of that contention, Respondent has no cases where courts have been permitted to exceed Article III under a pragmatic standard.
Do you have any cases where they've been denied?
Yes, Your Honor. Hayburn's case in 1792. We'll move it up a little. Muskrat v. United States, the Keller case cited in our brief, and only last term in Morrison versus Olson, the very structure of the court's opinion in that case rebuts this pragmatic standard, because what the court did in that case, after stating the general rule of the strict limits of Article III and citing for that Muskrat, Hayburn's case, and the United States versus Ferreira case, the court examined the functions of the special division and said that they were not outside the strict limits of Article III. Then it went on to a pragmatic balancing, saying, nor do we consider that these functions impair the Article III functions, and then finally went on to determine that they did not impair the functions of the executive. And so this court has consistently, for 200 years, followed the strict limits of Article III. And as I say, there are no cases applying a pragmatic standard to anything that courts can do outside of those bounds. And sorry.
I ask you this, I know your time's limited. Let's assume for the moment that we agree with you and invalidate the act. Does that mean that we'd have to go back to the situation where district court judges have unfettered discretion with respect to sentencing, and on top of that you have a parole commission that, without respect to anybody except its own judgment, determines in fact how long how long defendants serve in prison? What's the solution if we accept your view?
The solution, Your Honor, is actually quite simple. Congress can simply pass the guidelines, in which case they will have the full force of legislation, and the old system with wide judicial discretion and the parole commission.
Well, Congress approved these guidelines.
Well, Congress has not passed these guidelines as legislation. Congress has sent them out, but sent out the authority. They have never actually passed the guidelines, and certainly, as Justice Torruella points out, the President has had no opportunity to do so either. But that is all that needs be done.
But we've had independent commissions in the United States going all the way back to the Interstate Commerce Commission.
Yes, sir.
I think at least 18 to 20 of them. How could our system function if the Congress couldn't delegate substantial authority to independent commissions? In this case, if you said Congress could determine the guidelines, before the guidelines were chosen and before the act became law, there were hearings that lasted over 2 or 3 years. Congress just can't do that, can it?
Well, Congress certainly can create a commission to continually come up with proposals for the guidelines, as in fact they have had a commission here where they've got a plan that they can ratify. They would have to constitute the commission so as not to involve the judiciary in it. However, that is something that could be remedied afterward if Congress, that would not save the sentence in this case. But if Congress desired to do that, certainly they could create a commission which would do a lot of the balancing for them. And then if this is as politically uncontroversial as Respondent suggests, Congress should have no difficulty in passing the guidelines.
You suggest that judges couldn't even be on an advisory commission? In other words, if Congress set up a commission to make recommended sentencing guidelines to it, you would take separation of powers far enough to say that they couldn't even avail themselves of judicial experience through membership on a committee which simply said, here's our best recommendation, now Congress, you do with it what you will.
Well, Your Honor, certainly the Congress may solicit the views of the judiciary.
But they can't sit on any advisory commission?
They can, Your Honor, I would say, for instance, the Judicial Conference can issue these things. The problem here is that there is a commission composed of judges on the commission removable by the President and of other non-judges also removable by the President. And so you've got the problem of the judges being subject to this for-cause removal, plus you have 4 other commissioners who, under the reasoning of Boucher, are subservient to the executive, and so it is the combination that would be a problem. But certainly there could be, the views of the judiciary can be solicited, as they have been in many other cases through the years. Thank you, Your Honors.
Thank you. We will take the case under advisement and report in due time. we had a hung jury for a while. I now announce the decision of the court. The best brief was Respondent's. The best oral argument was Rathburn. The best team was Petitioner. And may I say this, I perhaps speak for all three of us, but each will say a word or two. I've sat on a good many moot courts over the years, and I can say quite truthfully that I've never sat on a moot court where the briefs and the oral arguments had the high quality that yours have. I thought when I was reading the briefs that I've read a good many briefs over the years, filed both in the Supreme Court of the United States and also on circuit courts of appeals, and I would say that your briefs would be viewed as excellent whatever the court was in which they were delivered. And I certainly speak for all three of us when I congratulate all of you. I know this is the end of a long road. This is the 77th session of this honorable court, and all of us are proud to sit on it. Judge Wald?
Well, I'd just like to make three brief points. One is you have reinforced my notion of how important oral argument is. As many of you may know, it's becoming somewhat of an endangered species in many of our federal appellate courts because of the case volume, but many of us are hanging on for dear life. I really do think that there's such a terribly important function that oral argument performs in clarifying, refining issues in briefs, and in allowing that one brief moment of face-to-face confrontation between counsel and the court. The second point I would make is that I think the prime function of oral argument from the judge's point of view is getting you to answer our questions. And I know it may be as annoying as all get out to have us constantly interrupting you and jumping down your throat. But believe me, not only is that terribly important for us to flesh out our own very often tentative views as we go into oral argument, but I hate to tell you this, but it's also the only fun we get mostly. At least in appellate courts. At least in appellate courts, we look forward to it. It's sort of like people getting ready for the hunt. And the third and last thing I would say is one of you commented, and I thought very candidly and perhaps courageously, that really a lot of our hypotheticals are far-fetched. And I think in many cases they are, but I think it's important that we test you out and we test ourselves out with what seem to be far-fetched hypotheticals, because each time we're deciding a case, we are really trying to find out, and with your help, what the implications of a particular decision will be by testing it out. And you're the only people we can talk to about the case. We can't talk to professors or anyone else, so you have to help us in trying to formulate the contours of taking a particular position in a particular case. And my last comment is that's particularly important in an area like separation of powers, which, despite the fact that it's had a growth stock in recent years, and we do have 5 or 6 or 4 or 5 Supreme Court precedents, still the principles are not always easy to get at first glance, and it's not always easy to figure out exactly where those principles are going down the line. And so that's why I think in this kind of case, we do pepper you with hypotheticals. I thought you all did. You were very tolerant of us.
It has been a great pleasure and honor to serve on this court. I have enjoyed it immensely. In preparing for this hearing today, I had the advantage, which you did not have because of the rules, to read both the briefs that were filed before the Supreme Court and the transcript of the oral argument. And I wish to tell you that, in my opinion, your briefs and the quality of the oral argument were at least as good as what I saw before the Supreme Court. I think that I speak also for the rest of the court in congratulating you. And of course, there are hard choices to be made, and making the decision in this case was not very easy. I did not have a chance to write a dissenting opinion. And the last thing I would like to say is I hope to see you all soon before us in the First Circuit.
The court will now adjourn.